Appellant's emergency notice of egregious filing obstruction by the court. Appellant Justin Riddle hereby brings to this court's attention an act of unprecedented and indefensible interference with his right to submit his reply brief on July 4, 2024, an act that represents a dire threat not only to Mr. Riddle's individual rights, but to the very foundations of our legal system and the future of our democracy. In a shocking display of targeted obstruction, the court has stooped to the extraordinary level of blocking Mr. Riddle's specific mobile device ID from being able to access the upload link on the court's electronic filing system. This blatant attempt to suppress Mr. Riddle's filing on the symbolically charged date of Independence Day, a date he deliberately chose to highlight the core constitutional values at stake in this appeal, is as shameful as it is revealing. But the implications of this misconduct go far beyond Mr. Riddle's personal struggle. If this court can so brazenly disregard evidence, obstruct a litigant's right to be heard, and flout the very principles of due process and fairness that form the bedrock of our legal system, it calls into question the legitimacy of the entire judiciary. What good are legal precedents and constitutional rights if the courts themselves are unwilling or unable to uphold them? Mr. Riddle's case has the potential to be a defining moment precisely because it exposes these deep-seated flaws within our institutions. It forces us to confront uncomfortable truths about the power imbalances, the lack of accountability, and the potential for abuse that plague our system of justice. And in doing so, it could serve as a catalyst for the kind of systemic reforms needed to restore the integrity of our courts and the vitality of our democracy. By raising public awareness about these critical issues, setting a precedent for future litigants to challenge institutional injustice, and sparking a broader conversation about the urgency of legal and political reform, Mr. Riddle's fight transcends his own personal circumstances. It is a fight for the soul of our nation, for the proposition that everyone, regardless of status or position, is entitled to equal justice under the law. That is why this court's attempt to obstruct Mr. Riddle's filing is so egregious, so dangerous, and so antithetical to its most basic responsibilities. It represents a direct assault on the values and aspirations that define us as a society. And it cannot be allowed to stand if we are to maintain any hope of realizing our founding ideals. If this court has even a shred of fidelity to its constitutional duties and the rule of law, it will take immediate action to investigate this outrage, accept Mr. Riddle's brief as timely filed, and send an unequivocal message that such attacks on the fairness of our system will not be tolerated. Accordingly, Mr. Riddle demands that this court 1. Immediately open a full and transparent inquiry into this reprehensible effort to obstruct his filing. 2. Issue an order deeming his reply brief as properly filed on July 4, 2024, nunc pro tunc, in light of the video evidence of the court's own misconduct. 3. Impose the harshest possible sanctions against those responsible as a necessary deterrent and a first step toward restoring a modicum of integrity to these tainted proceedings. The stakes could not be higher. The world is watching to see whether this court will rise to the challenge of this pivotal moment and reaffirm the core values that make our system of self-government possible. The choice, and the judgment of history, lies squarely with this court. Respectfully submitted, Justin Riddle. Pro se appellant dated, July 4, 2024. Forward. A decade-long quest for justice and accountability. In the annals of American jurisprudence, few cases present as compelling and comprehensive a challenge to the integrity of our legal and governmental institutions as the one before you. For almost a decade, Justin Riddle has waged a relentless campaign for truth, accountability, and justice, navigating a labyrinth of courts, agencies, and bureaucracies that have consistently failed to uphold their most fundamental responsibilities. This document represents not merely a legal brief, but a damning indictment of systemic failures that stretch from local courts to federal agencies, from state regulators to the highest levels of government oversight. What began as a simple dispute over a mortgage has unraveled into a Kafkaesque nightmare that exposes deep-seated dysfunction within our institutions of justice and governance. Mr. Riddle's journey is extraordinary not only for its longevity and persistence but for the meticulous documentation of every interaction, every falsehood, and every abdication of responsibility he has encountered. From recorded conversations with law enforcement to transcripts of Supreme Court arguments, from email exchanges. 1. With regulators to video evidence of public meetings, this case presents an unparalleled body of evidence that cannot be dismissed or ignored. Necessarily, even after achieving a unanimous victory in the Nebraska Supreme Court, Mr. Riddle has continued his quest for accountability. His recent discovery of a sham investigation by the Nebraska Attorney General's office hidden from him for years only serves to underscore the ongoing nature of the institutional failures he has been fighting against. The wall of silence Mr. Riddle has encountered from media outlets, elected officials, and oversight bodies is not merely frustrating, it is deeply alarming. It suggests a system so entrenched in its own self-protection that it will ignore even the most well-documented evidence of wrongdoing. This case transcends partisan politics or individual grievances. It strikes at the heart of what it means to have a functioning democracy governed by the rule of law. When every level of government, from local school boards to every level of court, to all regulators and citizen advocacy agencies demonstrate a willingness to ignore evidence, violate rights, and shield itself from accountability, we face a crisis that threatens the very foundations of our republic. 2. As you read this brief, consider not just the legal arguments within, but the broader implications for our society. This is not just about one man's struggle for justice, it is about whether our institutions can still fulfill their fundamental purpose of serving the public and upholding the law. The evidence presented here demands action. It calls for a thorough, independent investigation of the systemic failures exposed. It requires a reevaluation of how our institutions handle citizen complaints and evidence of misconduct. Most importantly, it necessitates a renewed commitment to transparency, accountability, and the rule of law at every level of government. This case stands as a testament to the power of individual perseverance in the face of institutional intransigence. It is both a wake-up call and a roadmap for the critical reforms needed to restore faith in our system of governance. The question now is not whether these problems exist, the evidence is irrefutable, but whether we, as a society, have the courage and integrity to address them. On this 4th of July, as we commemorate the birth of our nation and the principles upon which it was founded, we are reminded of the profound sacrifices made to secure and preserve our constitutional freedoms. The document before you is not merely a legal brief, but a testament to the enduring struggle to uphold the 3. Ideals enshrined in our Constitution, ideals for which countless brave men and women have given their lives. As we celebrate our independence, we must also recognize that the fight for liberty and justice is ongoing. Each generation bears the responsibility to safeguard these hard-won rights against erosion and abuse. This case, submitted on a day that symbolizes our nation's commitment to freedom and self-governance, represents more than an individual grievance. It is a call to reaffirm our collective dedication to the rule of law, to equal justice, and to the proposition that no entity, no matter how powerful, stands above the Constitution. The Founders' vision of a government accountable to its citizens and bound by clearly defined limits on its authority is not a relic of history, but a living mandate that demands our vigilant defense. In presenting this brief on Independence Day, we honor those who have sacrificed for our freedoms by insisting that their sacrifice was not in vain, that we, as citizens and as a nation, still have the courage to stand up for the principles they died to protect. Appellant's response brief. Statement of jurisdiction. The District Court had jurisdiction over this civil rights action pursuant to 28 U.S.C. 4. Sections 1331 and 1343, as it arises under the Constitution and laws of the United States, including 42 U.S.C. Section 1983. The District Court entered a final order dismissing all of Plaintiff Appellant's claims on April 19, 2024. Plaintiff Appellant filed a timely notice of appeal on April 23, 2024. This court has jurisdiction pursuant to 28 U.S.C. Section 1291. Statement of the case. This appeal arises from a proceeding so deeply flawed, so demonstrably biased, and so utterly dismissive of the rights of a citizen and his family that it demands the most stringent scrutiny from this court. The District Court's dismissal of this case represents not merely a miscarriage of justice, but a chilling indictment of the state of our democracy. In its haste to dismiss this case, the District Court ignored critical evidence, misrepresented the facts, and applied an arbitrary and undefined standard to dismiss Mr. Riddle's claims. The District Court's actions represent a clear pattern of systemic bias against pro se litigants. This court must act to safeguard the fundamental rights of all citizens, regardless of their financial means or legal sophistication. A. The parties. Appellant, Justin Riddle, is a citizen of Omaha, Nebraska, and a frequent participant at Omaha Public Schools Ops Board meetings. Mr. Riddle has been a vocal advocate for transparency and accountability in the Ops system. 5. Applee, Ops, is a public school district serving over 50,000 students in Douglas County, Nebraska. It is governed by an elected Board of Education. B. Public participation at Ops Board meetings **** Ops Board meetings are subject to the Nebraska Open Meetings Act, Neb. Rev. Stat. Sections 84-1407 to 84-1414, the Act. The Act requires that public boards provide advance notice of their meetings to facilitate public participation. Neb. Rev. Stat. Section 84-1411, 1a. Notably, the Act unambiguously provides that a public body shall require any member of the public desiring to address the body to identify himself or herself, including an address and the name of any organization represented by such person unless the address requirement is waived to protect the security of the individual. Neb. Rev. Stat. Section 84-1412, 3, emphasis added. Ops is granted authority to implement that requirement and others through reasonable rules and regulations promulgated by the board. Neb. Rev. Stat. Section 84-1412, 2. The rules relevant to plaintiffs' claims are set forth at Ops Policy 8346. R-Doc. 8-1, X. A. Subpart A provides members of the public the right to attend board meetings, without identifying themselves as a condition of admission. ID. X. A. At 1. Subpart E then establishes additional requirements for persons in attendance who desire to address the board. ID. X. A. At 2-3. Specifically, members of the public will be permitted to speak at board meetings at which a public comment is on the agenda. ID. In those instances, members of the public may speak during the time at which the public comment agenda item is 6. Being addressed. ID. While members of the public are not required to have their name placed on the agenda prior to the meeting in order to speak, they are required to complete a request to be heard form. ID. The form must be submitted no later than 5 minutes after the meeting has been called to order. ID. The board president has the authority to determine the order of speakers, subject to the limitation that students be granted preference to speak first. ID. As to the manner in which the speaker may address the board, Subpart E incorporates and cites the statutory command at issue verbatim. Once called to the podium, Nebraska Revised Statute Section 84-14-12-3 requires that members of the public identify themselves, spelling their name, stating an address and the name of any organization the member of the public is representing. Members of the public may request that the address requirement be waived to protect their security by so stating on the request to be heard form. ID. Emphasis added. Subpart E then states that, while at the podium, the speaker shall not approach the board table or individual board members. ID. For both speakers and attendees, the board president may order persons who are disorderly to be removed from the meeting and or direct the microphone be turned off. ID. X. A. At 1. C. The August 2, 2021 board meeting. Critically, no announcement of the recent rule changes were made by Hallman. 7. To the community. There was no mention of the statutory requirements whatsoever, just a general suggestion to state your address and no ability to opt out on the sign-up form. On August 2, 2021, the Ops Board convened for a meeting at which public comment was on the agenda. Plaintiff and his mother, Cheryl Adamson, were among those in attendance who desired to address the board. R.Doc. 1. At 2. Having been the first time at the meeting since the new rules regarding the address compliance, plaintiff and his mother were unaware of the recent changes to the address rules. Upon commencement of the public comments, although Hallman did ask that members of the community state their address, she did not cite the new rules, and as such, Riddle, viewing the rule as a measure to chill speech, was not aware that it was a requirement as it was not properly announced. Plaintiff's mother was called to the podium prior to plaintiff, informed the board that she lived in Omaha, Nebraska, stated and spelled her name, and when asked to state her address, responded that her husband would not appreciate that. When Dr. Hallman next inquired whether Ms. Adamson was part of OPS, she affirmed that she was and had served as a teacher with the district and retired as an ops employee of 36 years. At that time, Ms. Adamson was allowed to proceed with her remarks. After offering introductory comments, Ms. Adamson attempted to play a cell phone voice recording, at which time Dr. Hallman falsely told the speaker that ops need her public comment, but not an audio of someone else's comment. This is a patently false statement, easily disproved by a litany of audio and video. 8. Presentations at the school board meeting from multiple members of the community. One such example is here. Equally notable is that in over 3 years, Omaha Public Schools has flatly refused to answer a single question presented, including questions percentage in the form of Freedom of Information requests. The closest they have come to answering questions was 146 fully redacted pages. Even the most basic of requests, Omaha Public Schools has chosen to ignore, emboldened by seemingly unchecked authority. Plaintiff himself then came to the podium to assist Ms. Adamson as he believed it was an issue with the phone, unaware that the board president Hallman had implemented a non-existent policy specifically to Adamson in an effort to silence the information that was of such concern. As the recording was being transmitted, an ops security official can be seen approaching the podium, at which point plaintiff and Ms. Adamson were forced to return to their seats. Ultimately, Hallman, in a brazen act of viewpoint suppression, created a fake rule stating that recordings cannot be played. Countless members of the community have subsequently and likely previously played recordings, as this was a false, arbitrarily enforced lie presented by Ops Board President Hallman in an effort to prevent speech critical of the district. Both the complaint and OPS's motion to dismiss referenced the publicly available video recordings of the board meetings in which plaintiff participated. The videos are public records, which Neb. Rev. Stat. Section 84-712.01 defines as all records and 9. Documents, regardless of physical form, of or belonging to this state, any county, city, village, political subdivision, or tax-supported district in this state, or any agency, branch, department, board, bureau, commission, council, subunit, or committee of any of the foregoing, unless exempted by statute. The district court reviewed and considered the video of the meeting, however, in an incredible and unprecedented refusal of due process, failed to consider any of the other properly submitted evidence, including the extensively quoted recording from Lieutenant Ott. Porous Media Corp. vs. Paul Corp. 186 F3D 1077, 1079 8th CIR. 1999, a court may consider the complaint, matters of public record, orders, materials embraced by the complaint, and exhibits attached to the complaint in deciding a motion to dismiss under Rule 12b-6. Several other speakers addressed the board next. When plaintiff was then called to the podium, he stated, "My name is Justin Riddle. I live in Omaha. My address is irrelevant. I'm not required to give it. Board President Dr. Hallman reminded plaintiff about the statutory requirement that the speaker state his address. Plaintiff stated, "It's not a law, and my time will start now." Plaintiff was mistakenly operating under the previous rules due to the lack of any formal announcement of the new rules, and the fact that merely stating, "My husband wouldn't appreciate it," was sufficient reason for Adamson to speak without disclosure. Dr. Hallman then asked staff to turn off the podium microphone. After the microphone was quieted, plaintiff turned and addressed the audience for a brief time, and then directed his attention at Dr. Hallman specifically, pleading for his 10. Constitutional right to speak. Plaintiff was then removed from the meeting by a security official and a uniformed police officer. A recess was taken, after which the meeting recommenced and proceeded. D. Plaintiff's subsequent participation at OPS board meetings. Understanding the significance that OPS was intent on hiding the facts and preventing anyone from speaking out against their behavior, Mr. Riddle appeared and actively participated at subsequent meetings, each of which the proper rules were announced. In each subsequent instance, plaintiff provided his name and address, and was then allowed the allotted time for public comment. Plaintiff was also allowed to play audio at subsequent meetings, as it was always and continues to be allowed, despite the findings of the hidden AG investigation claiming otherwise. Notably, the unequal and arbitrary enforcement of the address requirement is clear and obvious in the following school board meetings. The district continues to require Riddle and others that share his viewpoint to give their address, while allowing arbitrarily others not to. E. The Harassment Protection Order. 11. Plaintiff links underlying violations of the 14th Amendment in the issuance of a state court protection order. R. Doc. At 4-5, 8. Plaintiff is referencing the harassment protection order imposed against him in favor of former board president Dr. Hallman, which was requested in her personal capacity. R. Doc. 8-1, X. B. Hallman vs. Riddle, No. C. 218450 Neb. Dist. Court. Sept. 16, 2021. Dr. Hallman filed a Nebraska state court action seeking a harassment protection order on August 23, 2021, after the encounter with plaintiff at the August 2, 2021 OPS board meeting. ID. A state court judge entered the protection order ex parte, and plaintiff was served with a copy by the Douglas County Sheriff. ID. Plaintiff subsequently requested a hearing to contest the order, as the applicable state procedure allowed. ID. On September 16, 2021, a hearing was held. ID. Plaintiff requested Lieutenant Ott testify, the head of OPS school resource officers, but Ott refused to do his duty. Both Dr. Hallman and plaintiff appeared and presented evidence. While presenting their cases, the judge allowed for highly prejudicial comments regarding the plaintiff and Kyle Rittenhouse, where the attorney for Baird Home claimed that Riddle was somehow dangerous and that Kyle Rittenhouse is a murderer who crossed state lines and killed two protesters, while completely ignoring the facts and evidence already available in that pending case. The judge, unfamiliar with the case, accepted their lie as true, overruled Riddle objecting based on the evidence and procedure, and ignored that the officer would not testify, effectively leaving a portrait of Riddle as an unstable citizen based on lies and due process violations. 12. That a judge in charge of making decisions on life or death and incarceration of citizens should certainly have known. Following the hearing, the court entered an order extending the harassment protection order for a period of 1 year from the original date of entry. ID. As stated, plaintiff did not appeal the ruling as it was clear that either the judge was willing to ignore prejudicial speech and key witnesses who refused to testify, or the judge was unfamiliar with the most basic duties under the rules of procedure. No appeal would change the situation when the facts and due process didn't matter in the first hearing. ID. Plaintiff, realizing that the judge had no interest in the truth or even basic due process, chose not to waste more money on appealing what was clearly a seriously biased and quasi-criminal hearing. F. The lawsuits. This is plaintiff's second lawsuit concerning the above events. See Riddle vs. Omaha Pub. SCH. Number 823 CV00455D Neb. October 17, 2023. The earlier action likewise sought relief under 42 U.S.C. Section 1983 against OPS as an entity alone, but claimed that in addition to the First and 14th Amendment, OPS also violated plaintiff's Second Amendment right to bear arms. Plaintiff voluntarily dismissed the earlier action after OPS filed a motion to dismiss, filing this action making many of the same claims within a few weeks. Subsequently, the Fifth Circuit decision has been overturned, so although Riddle could conceivably reintroduce the 2A claim, he sees no need. 13. Plaintiff demonstrated the quieting of his microphone at the August 2, 2021 OPS board meeting, his subsequent removal from that meeting, and his illegal blocking on the official district social media accounts of various OPS employees, including the superintendent, the director of equity and diversity and the board president and board members, the calls from multiple officers, the false information given to the AG during the hidden investigation, the continued inconsistent address requirements, the refusal of NA AG's office in Omaha Public Schools to provide any meaningful information. Instead receiving denials to that public information or completely redacted pages, violated and continues to violate his right to free speech. R. Doc. 1, at 2 to 4, 5 to 8. Plaintiff simply and plainly contends that the initial silencing and each subsequent escalation by the district and their representatives were attempts to silence and chill not just his, but the speech of anyone who bears witness to the malfeasance. Plaintiff has also demonstrated that multiple individuals necessarily acted in coordination, through timing, common sense and the admission from Ott himself that he was notified and involved based on the information he received from the district. Plaintiff further demonstrated the harassment protection order issued in favor of Dr. Hallman violated his 14th Amendment procedural due process rights. ID. At 8. In support, plaintiff demonstrated the protection order was baseless, in part because Officer Otto refused to testify, and Dr. Hallman waited until after Officers Lee and Otto had taken a swing at intimidating plaintiff into silence before. 14. Filing for a protection order. It's clear that considering Lee and Ott were armed with the truth, Hallman would not allow the officers to testify, as they would have had to respond honestly to her, as they did in writing, prior to her filing of the suit, indicating that Riddle was not a threat. Notably absent from her claims, was any substation or offered testimony from either of the professional law enforcement officers tasked by the district and school board with assessing Riddle and others. ID. At 4 to 8. Finally, plaintiff proved that the phone calls by Officers Otto and Lee constituted an attempt to intimidate plaintiff and infringe on his First Amendment rights, attributable to ops through a conspiracy between the district, the board, and OPD. ID. At 9. The conspiracy, although unnecessary, is further supported through unwarranted home visits and phone calls to persons other than plaintiff who agreed or supported the same positions as Riddle. More importantly, plaintiff provided an audio recording of the conversation with Ott, wherein Ott admits that he 1. Was notified by the district. 2. Was sent emails from me. 3. None of my emails were threatening. 4. Nothing I said was violent. 5. He was aware of Officer Steve Lee having contacted me and was aware that he also said I was of no danger to anyone. 6. He was representing the school district. 7. He had discussed with the board that they should announce the rules every meeting. 8. I had complied with the rules every subsequent meeting. 9. He was a representative of the district. ID. At 5 to 9. In a shocking abdication of duty, the lower court ignored that phone call in its entirety, despite not questioning the validity and it being 15. Extensively quoted in the complaint. This phone call alone proves the fundamental issues of the entire complaints, including the fact that Lieutenant Ott was aware of Officer Lee's prior contact, was contacted by the school district, admits to being part of and the head school resource officer for Omaha Public Schools, and that he hadn't witnessed the alleged bad behavior but was notified via email and other communications from the district. This is important, as the lower court claimed that no conspiracy occurred, but using the legal definition of conspiracy, as stated on, a conspiracy is an agreement or plan, made between two or more people, to engage in an illegal act, to obtain an unlawful objective, or to deprive another person of his legal rights. While the challenge could be made that no attempts were made or rights were ultimately deprived, the evidence quickly dispels that notion, and does not change the underlying motivation behind the communication that Ott admits in the call. It also ignores the fundamental fact that Ott admitted to being involved based on information from the district, and that correspondence would provide great insight as to whether or not Omaha Public Schools had the intent to intimidate or otherwise discourage plaintiff from attending and speaking at the meetings. G. The district court's order. OPS timely filed a Rule 12 motion to dismiss in response to the complaint, alleging a generically standard lack of standing to raise third-party claims under Rule 16. 12b-1 and equally alleging a generic failure to state a claim under Rule 12b-6. R. Doc. 6. In support of the latter, OPS argued both that the complaint failed to allege action pursuant to an official policy or unofficial custom, necessary to state a claim against a local governmental body under Monell, and further that the complaint failed to allege any actionable underlying constitutional violation. This also is based on the precise failure of Omaha Public Schools to acknowledge that they called multiple officers on multiple people, which is both a pattern and unofficial custom. Clearly, the minimum standard of Monell doesn't require more than what Riddle has proven, which is why the uncontested call with Ott has been ignored by everyone involved. ID. The district court overruled the Rule 12b-1 motion, but granted the Rule 12b-6 motion on Monell grounds and dismissed the case. R. Doc. 16. Putting aside whether the actions taken against Riddle himself were unconstitutional, the court oddly found that Riddle's allegations were too conclusory and vague to eke out a claim of widespread unconstitutional conduct. ID. At 8. The court concluded that the complaint did not plausibly allege a persistent pattern of unconstitutional misconduct, but rather set forth a slew of mismatched complaints that are not similar, consistent, or widespread enough to meet the demands of Monell. ID. At 9 to 10. Finally, the court concluded that Riddle's conspiracy claim failed for the same reason, as Riddle did not plausibly allege that OPS itself participated in the conspiracy through a policy, custom, or action by persons with final decision-making authority, a necessary element of a Section 1983 conspiracy claim against a public. 17. Body. ID. At 11. Because the lower court failed to recognize basic facts such as how many children Riddle had, the clear evidence from the phone call, and the absence of Omaha public schools proving that audio recordings are not allowed that they used to silence Adamson, etc., Riddle did not seek leave to amend his pleading, but instead timely appealed. Riddle additionally determined that based on the one-day turnaround from his ongoing harm, and the dismissal that completely ignored it, the lower court had simply been wasting time by not responding to the brief until it realized that the district continues to be abusive, and any delays could make it harder to keep ignoring the facts. This follows the path of ignoring a fair and speedy process, but more importantly, is a continuation of the repeated process that plaintiff has faced with every judge and state-funded organization, a complete lack of due process, common practices and fair evaluation. Perhaps most troubling is how the lower court put more effort into finding ways to claim that the cops calling on behalf of the school district, the restraining order, the illegal blocking on social media and the misrepresentations of the defense were all irrelevant, while trying to persuade normal people that it's completely acceptable for not one, but two police officers to show up at a high school student's house for merely showing up, not even speaking at a board meeting, and merely asking to search his room. The suggestion is that by cops asking, there's no reason that a high school student or anyone else would feel trepidation for being approached by multiple officers at their home, when they hadn't even given their 18 name or spoken at the meeting. It ignored the actual effort required to figure out who the student was because, as stated, he was a silent participant at the meeting and used an anonymous Twitter handle, and further ignored that these are the same tactics used by violent, oppressive regimes throughout history. The mere suggestion that asking for permission changes the underlying constitutional issue is as concerning as the lower court being unable to count the number of children the plaintiff has. Notably, ignoring the child who at 4 years old and a special needs child on an IEP with OPS was a seemingly deliberate choice, as he will be in the district for the longest. The Nebraska Attorney General's sham investigation **** after the August 2, 2021 Ops Board meeting, multiple members of the community, not Riddle or Adamson, filed a complaint with the Nebraska Attorney General's office alleging violations of the Open Meetings Act by Ops. The Attorney General's office conducted an investigation, but Riddle was never notified of the investigation, nor was he given an opportunity to provide evidence or testimony. The Attorney General's office ultimately issued a letter concluding that Ops had not violated the Open Meetings Act. The letter, however, contained false statements about Riddle and his mother, claiming they were the abusers, not the victims, of the alleged Open Meetings Act violations. Riddle was not made aware of this letter until he discovered it by accident in May 2024. Riddle subsequently contacted the Attorney General's office to express his concerns. 19. About the sham investigation and the false statements in the letter. R.Doc. 33-1. The Attorney General's office refused to correct the errors in the letter, refused to provide Riddle with any information about the investigation, and ultimately banned Riddle from the Attorney General's office. Incredibly, Omaha Public Schools did not use this seemingly silver bullet of a complete exoneration by the Attorney General's office in the response to Riddle's lawsuit. OPS was involved, they had participated and been CC'd on this investigation and knew that Riddle was unaware of it and that they had lied in their response, which the Nebraska Attorney General's office then published as the reason to claim they had done nothing wrong. Alternatively, systemic incompetence would substitute systematic rot, in the case that every single person involved is incapable of following the most basic of bedrock procedures. Additionally, as evidenced by the videos the Attorney General's office repeatedly expelled Riddle from its premises and refused to directly address his concerns about the lack of due process in its investigation. These videos show AG staff and Capitol Police forcing Riddle to leave the buildings when he attempted to get answers, with the AG representatives repeatedly evading his questions and failing to provide any substantive explanation for their one-sided actions against him. The AG, when presented with their own lies and deception, chose to use tactics similar to the Nazis' SS, and refused to change course, instead compounding the past misdeeds. 20. With current, equally egregious and illegal acts. It further demonstrates the same strategy used by Omaha Public Schools of lying to law enforcement in an effort to avoid any factual discussions. By falsely claiming to the Capitol Police that Riddle was being disruptive, and banning Riddle from the state capitol for life, the Nebraska AG's office has ramped up their level of aggression against a citizen in a way that can only be described as a hard line in the sand where the truth is on the other side and they refuse to cross into reality. This misconduct exemplifies the AG's prejudicial animus and deprivation of Riddle's rights in conducting a blatantly biased sham investigation. It further provides uncontested evidence that on multiple occasions, plaintiff calmly and properly requested information, but rather than address the facts and evidence, those with the privilege of serving the public, used their authority to wield law enforcement against the truth, rather than their pen against the lies. It is the same brazen strategy used throughout history to silence criticism and retain control, by force if necessary. Such conduct mirrors historical instances of authoritarian suppression, as notably outlined in Adolf Hitler's Mein Kampf, where the suppression of dissent is advocated through centralized authority, propaganda, and ruthless measures. Hitler emphasized the necessity of eliminating opposition to maintain control and enforce his ideology. Similarly, the Nebraska AG's office, and indeed Nebraska government offices in general, appear to employ a comparable strategy, utilizing its authority and law enforcement to silence Riddle and evade accountability, thus. 21. Maintaining their narrative and control. This parallel underscores a concerning pattern where those in power prioritize silencing dissent and evading the truth over transparency and justice. 2. The Nebraska Ombudsman's Office failed to investigate OPS's misconduct. Mr. Riddle's complaint also alleges that the Nebraska Ombudsman's Office, a state agency tasked with investigating complaints against government entities, failed to properly investigate OPS's actions. This failure further demonstrates the systemic bias and lack of accountability within the Nebraska government. Specifically, Mr. Riddle alleges that the Ombudsman's Office refused to investigate his complaints against OPS, including the silencing of his speech at board meetings and the arbitrary enforcement of public comment restrictions. Notably, Riddle has recorded multiple other examples of this unethical and unconstitutional behavior, including a conversation in which the first question from the Nebraska Ombudsman's Office was who he was filing the complaint against. When he said the Attorney General's office, instead of informing him immediately that they couldn't investigate the Attorney General, they gathered all his information and story, only to later claim they couldn't investigate. This pattern of behavior, as detailed in the video evidence provided, demonstrates a clear attempt to avoid 22. Investigating OPS's misconduct and a willingness to prioritize protecting the interests of powerful institutions over the rights of citizens. The Ombudsman's Office is a critical mechanism for holding government entities accountable. Its failure to investigate Mr. Riddle's complaints undermines the very purpose of its existence and further erodes public trust in the state's oversight mechanisms. The court's dismissal of Mr. Riddle's claims against OPS, coupled with the Ombudsman's Office's inaction, sends a chilling message that government entities can violate citizens' rights with impunity. This court should consider the Ombudsman's Office's failure to investigate as a significant factor in determining the systemic bias and lack of accountability within the Nebraska government. This failure further strengthens Mr. Riddle's claims against OPS and highlights the need for robust judicial oversight to ensure that government entities are held accountable for their actions. 3. The Nebraska Department of Banking and Finance ignored evidence of bank misconduct. Mr. Riddle's complaint also alleges that the Nebraska Department of Banking and Finance (DOB&F) failed to properly investigate his complaints against Charter West Bank, a financial institution operating in Nebraska. This failure further demonstrates the systemic bias and lack of accountability within the Nebraska government. 23. Specifically, Mr. Riddle alleges that the DOB&F, despite being presented with evidence of Charter West Bank's misconduct, pretended not to understand basic banking and finance principles. This inaction allowed the bank to continue its unethical practices, further harming Mr. Riddle and other individuals. The Nebraska Ombudsman's Office also refused to properly investigate the DOB&F in Riddle's case against Charter West Bank in 2019, as shown in this video. Furthermore, the DOB&F's pretense of not understanding basics about banking and finance is captured in this video. The DOB&F, like the Ombudsman's Office, is a critical mechanism for holding financial institutions accountable. Its failure to investigate Mr. Riddle's complaints undermines the very purpose of its existence and further erodes public trust in the state's regulatory mechanisms. This court should consider the DOB&F's failure to investigate as a significant factor in determining the systemic bias and lack of accountability within the Nebraska government. This failure further strengthens Mr. Riddle's claims against OPS and highlights the need for robust judicial oversight to ensure that government entities are held accountable for their actions. IV. OPS's indemnification of Hallman demonstrates a pattern of protecting misconduct. 24. Mr. Riddle's complaint also alleges that OPS, in a blatant disregard for accountability, voted to indemnify Dr. Hallman against any liability or costs arising from her actions, including procuring the baseless protection order against Mr. Riddle. More incredibly, they allowed Hallman to vote for herself in the very indemnification in question. This decision further demonstrates OPS's willingness to shield its officials from consequences for their misconduct and to prioritize protecting its interests over upholding the rights of citizens. This decision by OPS, coupled with the other allegations of misconduct, reinforces the pattern of systemic bias and lack of accountability within the organization. It also raises serious concerns about the potential for future misconduct by OPS officials, knowing that they are protected from any repercussions. This court should consider OPS's decision to indemnify Dr. Hallman as a significant factor in determining the systemic bias and lack of accountability within the organization. This decision further strengthens Mr. Riddle's claims against OPS and highlights the need for robust judicial oversight to ensure that government entities are held accountable for their actions. Summary of the argument. The district court's dismissal of Mr. Riddle's complaint is a travesty of justice. It rests on an improperly restrictive reading of his factual allegations and a blatant disregard for substantial record evidence of unconstitutional conduct. Viewed. 25. Through the appropriately liberal lens afforded pro se pleadings, the complaint states plausible claims for municipal liability and conspiracy under 42 U.S.C. Section 1983. The complaint alleged a clear pattern of retaliatory and discriminatory conduct by multiple ops officials in response to Mr. Riddle's protected speech, including acts of censorship at board meetings, district officials blocking him on social media, abuse of disciplinary procedures, and the procurement of a baseless protection order without due process. The temporal proximity of these actions to Mr. Riddle's speech, combined with the breadth of officials involved and the consistent focus on silencing his particular viewpoint, supports a reasonable inference of an unconstitutional custom or practice ratified by ops policymakers. Only by ignoring all of the evidence and claiming that all of these necessarily linked items are unrelated, was the lower court able to manufacture a response that indicates otherwise. The district court improperly dismissed Mr. Riddle's conspiracy claim as conclusory while overlooking clear factual evidence provided in the complaint. Most notably, the complaint detailed a recorded phone call with Lieutenant Charles Otto, head of Ops School Resource Officers, which provides direct evidence of coordination between Ops and law enforcement. Otto's admissions in this call, including that he was notified by the district about Riddle, was sent Riddle's emails, and discussed rule announcements with the board, demonstrate a clear link between OPS's actions and law enforcement involvement. This evidence, which the district court 26 inexplicably ignored, is more than sufficient to state a plausible claim of conspiracy at the pleading stage. Riddle has proven the connection and link. Discovery can prove that there was nothing inappropriate or nefarious in the process, if the district is confident that they have followed the laws. The district court erred by artificially compartmentalizing these allegations rather than viewing them in context as a cohesive narrative of misconduct. It further applied an improperly stringent standard to Mr. Riddle's pleading, demanding effectively conclusive proof of an unconstitutional policy at the outset of the case rather than allowing his substantial circumstantial evidence to proceed to discovery. And it completely ignored Mr. Riddle's notice of ongoing harm, which provided direct video evidence corroborating his allegations. The complaint also includes specific factual allegations supporting Mr. Riddle's conspiracy claim, including the verified coordination between school officials and law enforcement to conduct retaliatory home visits and investigations in an effort to intimidate and silence him. The district court improperly dismissed these allegations as conclusory while overlooking the clear factual basis provided in the complaint. This was a masterclass in creative writing by the court, as no one considering the available evidence could have missed how Lieutenant Ott clearly stated he was notified by the district. The level of effort required by the lower court to separate the clearly, verbally and evidence-proven connection between Lieutenant Ott and his employer Omaha Public Schools, borders on criminal neglect, not just incompetence or lack of training. This 27 was no mere possibility of wrongdoing, but documented, obvious coordination verbalized by the parties themselves. Even if the court didn't want to consider the call with Ott, it had an obligation to listen to it because of the extensive quotes. Upon doing so, it would be impossible to deny the significance of the call. The level of detail and clarity of Lieutenant Ott's words eliminate any doubt that multiple officers and multiple officials were involved. Imagine a case of alleged collusion between a mayor's office and a local construction company. 1. There's a recorded phone call between the mayor and the company owner discussing how to ensure the company wins an upcoming bid. 2. Emails show the mayor's staff sharing inside information about the bidding process with the company. 3. The company makes large donations to the mayor's re-election campaign just before and after winning the bid. 4. A whistleblower from the mayor's office testifies about being instructed to favor this company. 5. The winning bid is significantly higher than other qualified bids, costing taxpayers millions extra. Despite this seemingly irrefutable evidence, imagine the judge dismisses the case, claiming there's no proof of collusion. This would be an identical representation of the issue without using the emotional underpinning of the school district that seems to cloud judgment. 28. More broadly, the district court's dismissal exemplifies the unequal treatment too often afforded pro se civil rights plaintiffs. The court's uncharitable and factually inconsistent parsing of the complaint, measured against its uncritical acceptance of OPS's blanket denials, reflects a troubling predisposition to clear its docket rather than provide a fair hearing on the merits. Its disregard for Mr. Riddle's notice of ongoing harm raises further red flags about the integrity of the process below, as it clearly conflicted with the later decision from the court alleging no ongoing harm. Understand the significance of this. The document was only about continued and ongoing harm, but the court specifically ignored that in order to claim no continuing harm in the decision. There is no special or advanced legal training or education needed to understand that if someone submits a document titled, Continued and Ongoing Harm, dismissing the case based on no continued harm would at least require addressing how that harm was not real. In this situation, like all of the other evidence, the court just flatly ignored it. This court should reject such an outcome. The right to petition the government for redress of grievances and to express dissenting viewpoints on public affairs lies at the very core of the First Amendment. When state actors use the power of their office to systematically suppress and retaliate against disfavored speech, the law demands recourse. DeJong vs. Oregon, 299 U.S. 353, 365 1937. The courthouse doors must remain open to such claims, lest the Constitution's promise of free expression and government accountability ring hollow. Properly viewed, Mr. Riddle's pro se complaint clears the relatively low hurdle of 29. Rule 12b-6 and is entitled to proceed to discovery. This court should reverse the judgment below and remand for further proceedings on his substantial claims of municipal liability and conspiracy under Section 1983. Our most fundamental constitutional guarantees require nothing less. Argument. I. The district court erred in dismissing Mr. Riddle's Section 1983 municipal liability claim. A. Legal standard for municipal liability under Section 1983 *** to state a claim for municipal liability under 42 U.S.C. Section 1983, a plaintiff must allege 1. Action pursuant to an official municipal policy or custom, and 2. Deliberate indifference by the municipality to the risk of unconstitutional conduct. Monell vs. Dept of Society. Serves. 436 U.S. 658, 690-91 1978. At the pleading stage, these elements may be alleged through circumstantial evidence allowing a reasonable inference of an unconstitutional policy or custom. Doe ex rel. Doe vs. SCH. Dist. Of Norfolk, 340 F3D 605, 614 8 CIR. 2003. Allegations of a pattern of unconstitutional acts by municipal officials can support such an inference. Crawford vs. Van Buren County, 678 F3D 666, 669 8 CIR. 2012. The district court erred in dismissing the gravity of OPS's actions regarding a student who silently attended a board meeting. The complaint alleges that OPS dispatched 2 police officers to the student's home within 24 hours of the meeting. 30. Ostensibly to investigate a potential threat, compel. Paragraph Mark X. This action, taken without any evidence of disruptive behavior or threats from the student, raises serious constitutional concerns. Sending law enforcement to a minor's residence in response to their mere presence at a public meeting implicates both First and Fourth Amendment protections. See Steffel vs. Thompson, 415 U.S. 452, 462 1974. Recognizing that threat of prosecution for exercising First Amendment rights may have chilling effect. Doe vs. Heck, 327 F3D 492, 511-12 7th CIR. 2003. Discussing Fourth Amendment protections for minors in school context. Such actions, if proven, could constitute a clear attempt to intimidate and suppress constitutionally protected activity. It also calls into question the speed at which the officers identified a student with an anonymous Twitter account that didn't speak at the meeting. The student did not provide any personal information, indicating that merely showing up to the meeting was such a significant issue that it was necessary for law enforcement to quickly track down this potential danger. Yet oddly, no evidence of any danger was ever presented, described or alleged in the extensive call between Ott and Riddle. Moreover, this incident is not isolated but forms part of the broader pattern of alleged misconduct by OPS officials aimed at chilling dissent and public participation. The district court's failure to properly contextualize this event within the larger narrative of OPS's actions represents a significant oversight in its analysis. This court should consider the profound chilling effect such practices could have on 31. Student and community participation in school governance. When a school district employs law enforcement to investigate silent attendance at public meetings, it sends a clear message that discourages engagement and undermines principles of open government. See Brown v. Louisiana, 383 U.S. 131, 141-42, 1966. Discussing importance of protecting various forms of protest and civic participation. B. Mr. Riddle alleged a plausible pattern of unconstitutional acts by OPS officials. Viewed in the light most favorable to Mr. Riddle, the complaint alleges a clear pattern of retaliatory and discriminatory acts by OPS officials, including cutting off Mr. Riddle's microphone and ejecting him from a board meeting when he tried to voice concerns about OPS equity policies. Compel. Paragraph Mark 7-8. Enforcing public comment restrictions in a content and viewpoint discriminatory manner to silence Mr. Riddle's particular message. ID. Paragraph Mark 8. Conspiring with law enforcement to conduct baseless investigations and intimidating home visits in response to Mr. Riddle's advocacy. ID. Paragraph Mark 10. 15. Procuring a meritless protection order against Mr. Riddle without due process in an effort to stifle his speech. ID. Paragraph Mark 18-19. And barring Mr. Riddle from commenting on official OPS social media pages to prevent him from spreading his views. ID. Paragraph Mark 9. The close temporal proximity of these actions to Mr. Riddle's protected expression, combined with the number of officials involved and the consistent focus on chilling. 32. His speech raises a reasonable inference of a custom or unwritten policy ratified by OPS policymakers. See Davison vs. City of Minneapolis, 490 F3D 648, 659-60 8 CIR. 2007. Temporal proximity and alleged statements by officials supported inference of retaliatory motive attributable to city. The fact that OPS sought a baseless protection order and indemnified the official who procured it further supports an inference of official ratification. Cf. Pembauer vs. City of Cincinnati, 475 U.S. 469, 480 1986. It is plain that municipal liability may be imposed for a single decision by municipal policymakers. C. The district court improperly compartmentalized the allegations and ignored key evidence. In dismissing Mr. Riddle's Monell claim, the district court committed two key errors. First, it viewed each alleged act in isolation rather than considering the complaint's allegations in context as a mutually reinforcing pattern of misconduct. This improperly compartmentalized analysis obscured the larger picture of pervasive suppression of Mr. Riddle's speech by OPS actors and failed to credit the reasonable inferences of an unconstitutional policy that flow from the totality of the alleged circumstances. C. Wilson vs. City of Des Moines, 293 F3D 447, 451 8th CIR. 2002. Reversing Rule 12b-6 dismissal where district court viewed the various allegations in isolation, rather than in the context of the complaint as a whole. Second, the district court entirely ignored the notice of continued and ongoing damage Mr. Riddle filed just 1 day before the dismissal order. This notice 33 provided video evidence directly corroborating his allegations of systematic viewpoint discrimination by OPS and undermining the court's conclusion that he failed to plead an unconstitutional custom. The court's refusal to consider this highly relevant evidence, submitted in advance of its ruling, raises serious questions about the fairness of the proceedings below. Cf. Brooks vs. Midwest Heart GRP, 655 F3D 796, 808 CIR. 2011. Reversible error to grant Rule 12b-6 motion without addressing plaintiff's proposed amended complaint containing relevant factual allegations. D. Mr. Riddle's allegations exceed the pleading burden for municipal liability claims. The district court demanded an improperly high level of specificity and proof from Mr. Riddle's complaint, effectively requiring him to definitively establish an unconstitutional policy at the outset of the case. This rigorous standard is inappropriate at the pleading stage, where a plaintiff need only allege facts supporting a reasonable inference of municipal liability to unlock the doors to discovery. C. Swierkiewicz vs. Sorma N.A., 534 U.S. 506, 512 2002. Rule 8's simplified pleading standard relies on liberal discovery rules to define disputed facts and issues and to dispose of unmeritorious claims. Mr. Riddle's extensive factual allegations, bolstered by video evidence of ongoing misconduct, more than suffice to nudge his Monell claim across the line from conceivable to plausible. Bell ATL Corp. vs. Twombly, 550 U.S. 544, 570 2007. The district court erred by 34. Prematurely cutting off his claim based on an improperly demanding pleading standard. 2. The district court erred in requiring a pattern of misconduct when a single instance is sufficient to establish municipal liability. The district court's dismissal of Mr. Riddle's Section 1983 claims against OPS on the basis that he failed to allege a pattern of misconduct represents a fundamental misapplication of the law governing municipal liability. This error alone warrants reversal. A single decision by a municipal policymaker can establish liability. The Supreme Court has unequivocally held that municipal liability may be imposed for a single decision by municipal policymakers under appropriate circumstances. Pembauer vs. City of Cincinnati, 475 U.S. 469, 480 1986. This principle recognizes that when a final policymaker for a municipality takes an action that violates constitutional rights, that single decision can reflect or establish municipal policy sufficient to impose liability under Section 1983. B. The complaint alleges multiple instances of misconduct by final policymakers. Mr. Riddle's complaint details several specific instances of alleged misconduct by 35 high-ranking OPS officials, including the board president and superintendent. These officials indisputably possess final policymaking authority for the district. The complaint alleges, inter alia, 1. The board president's decision to cut off Mr. Riddle's microphone and eject him from a board meeting for criticizing OPS policies. Compl. Paragraph Mark 7-8-2. The superintendent's directive to block Mr. Riddle from OPS social media accounts. Compl. Paragraph Mark 9. 3. The board's decision to seek a baseless protection order against Mr. Riddle. Compl. Paragraph Mark 18-19. Each of these alleged actions, taken individually, could establish municipal liability under Pembauer if proven to be unconstitutional. C. The district court's pattern requirement conflicts with binding precedent. By dismissing Mr. Riddle's claims for failure to allege a pattern of misconduct, the district court imposed a requirement that directly contradicts Supreme Court precedent. This legal error alone necessitates reversal. Even if this court were to credit only one of the instances of policymaker misconduct alleged in the complaint, that single action could be sufficient to establish municipal liability under Pembauer. D. Requiring a pattern creates perverse incentives. The district court's approach, if adopted, would create troubling incentives for 36. Municipalities. It would allow them to evade liability by ensuring that each constitutional violation is unique rather than repeated. This outcome would severely undermine Section 1983's core purpose of deterring governmental misconduct and protecting citizens' rights. Conclusion. The district court's dismissal based on the lack of a pattern of misconduct represents a clear error of law that warrants reversal. This court should reaffirm that a single unconstitutional action by a municipal policymaker can establish liability under Section 1983 and remand for further proceedings consistent with that principle. 3. The district court misapplied the legal standard for municipal liability. Under Section 1983 the district court's dismissal of Mr. Riddle's claims against OPS fundamentally misunderstands and misapplies the legal standards governing municipal liability under 42 U.S.C. Section 1983. This error warrants reversal and remand for further proceedings. A. Legal framework for municipal liability. The Supreme Court established in Monell v. Department of Social Services, 436 U.S. 658 1978, that municipalities can be held liable under Section 1983 when a plaintiff's harm is caused by an official policy, practice, or custom. However, subsequent 37. Jurisprudence has clarified that this standard is more nuanced than the district court's analysis suggests. 1. Single incident liability. In Pembauer v. City of Cincinnati, 475 U.S. 469 1986, the Supreme Court held that municipal liability can arise from a single decision by municipal policymakers. The court stated, municipal liability attaches only where the decision maker possesses final authority to establish municipal policy with respect to the action ordered. ID. At 481. This principle was reaffirmed in Board of County Commissioners of Bryan County v. Brown, 520 U.S. 397 1997, where the court noted that a single decision could trigger liability if made by the appropriate policymaking official. In this case, Mr. Riddle has alleged multiple instances of misconduct by high-ranking OPS officials, including the board president and superintendent, who indisputably possess final policymaking authority. Under Pembauer, each of these alleged actions could potentially establish municipal liability if proven unconstitutional. 2. Custom or practice liability. While a pattern of similar constitutional violations is one way to establish municipal liability, it is not the only way. In City of Canton v. Harris, 489 U.S. 378 1989, the court held that liability can attach where the need for more or different training is so obvious, and the inadequacy so likely to result in constitutional violations, that policymakers can be said to have been deliberately indifferent to the need. 38. Mr. Riddle's allegations, taken as true at this stage, suggest a systemic problem in how OPS handles dissenting viewpoints. This could potentially satisfy the City of Canton standard, even absent a long-standing pattern of identical violations. B. The district court's erroneous application of the law ***. The district court erred in two significant ways. 1. Requiring a persistent pattern. The court's insistence on a persistent pattern of unconstitutional conduct misreads the applicable law. As demonstrated above, a single decision by a policymaker can be sufficient. The court's approach effectively immunizes municipalities from liability for novel forms of misconduct, contrary to the purpose of Section 1983. 2. Mischaracterizing allegations is mismatched complaints. By dismissing Mr. Riddle's allegations as a slew of mismatched complaints, the court failed to view the allegations holistically. The alleged actions, while varied in form, all relate to a consistent theme of suppressing Mr. Riddle's speech and retaliating against his advocacy. This cohesive narrative should have been sufficient to survive a motion to dismiss. C. Proper application of the law to Mr. Riddle's allegations ***. Viewed correctly, Mr. Riddle's complaint alleges 1. Multiple discrete actions by final policymakers, e.g., the board president's decision to cut off Mr. Riddle's microphone, each potentially sufficient under 39. Pembauer to establish liability. 2. A series of related actions that, taken together, suggest a de facto policy of suppressing dissent, potentially satisfying the custom or practice standard even without formal codification. 3. A failure to properly train or supervise staff in handling public criticism, which could satisfy the City of Canton standard if the need for such training was obvious given the public-facing nature of school board operations. D. Conclusion. The district court's dismissal rests on a fundamental misunderstanding of the legal standards governing municipal liability under Section 1983. This court should reverse the dismissal and remand for further proceedings, with instructions to properly apply the Monell framework as elucidated by subsequent Supreme Court decisions. At the motion to dismiss stage, Mr. Riddle's well-pled allegations are more than sufficient to state a plausible claim for municipal liability under the correct legal standard. IV. The district court judge displayed pervasive bias and misconduct requiring reassignment. The record reflects that the district judge displayed an inability to review Mr. Riddle's pro se complaint objectively and impartially. The judge's dismissive characterization of Mr. Riddle's well-pled factual allegations, harsh repudiation of 40. His claims without fairly considering the evidence, apparent disregard for the notice of continued harm, and statements evidencing prejudgment such as asserting Mr. Riddle needed to learn his lesson, and misrepresenting the number of his children. By omitting the very child whose interests as an autistic student are most at stake in this case, cumulatively undermine confidence that the judge can approach this case with the required fresh and open perspective. The district court's ruling in this case is marred by a pervasive pattern of bias, selectivity, and disregard for critical evidence that raises serious doubts about the fairness and impartiality of the proceedings below. Throughout the opinion, the court employs dismissive and prejudicial language that minimizes the gravity of Mr. Riddle's claims and suggests a predisposition against his case. By describing Mr. Riddle as having learned his lesson, and characterizing his allegations as conclusory and vague, without meaningful engagement with the factual record, the court reveals a lack of objectivity and a failure to afford due weight to the disturbing evidence of misconduct and retaliation by ops officials. Moreover, the court's excessive emphasis on technical pleading standards for municipal liability, at the expense of substantive analysis of the troubling facts alleged, indicates a misguided prioritization of procedural formalities over the pursuit of justice. In fixating on whether Mr. Riddle's complaint satisfies precise legal thresholds, the court largely ignores or glosses over the specific, compelling evidence presented of viewpoint discrimination, intimidation, and abuse of power by 41. Ops personnel. This selective treatment of the record suggests an undue deference to the institutional defendant and a corresponding disregard for the rights and interests of the individual plaintiff. The court's failure to properly contextualize the power dynamics between Mr. Riddle, a private citizen, and OPS, a government entity with vast resources and authority, further undermines the soundness and impartiality of its analysis. By equating Mr. Riddle's individual actions with the alleged systematic misconduct of a public school district, the court engages in a false equivalency that discounts the coercive impact of the power imbalance between the parties. Perhaps most troublingly, the court's opinion fails to consider the profoundly chilling effect that its reasoning could have on the free speech rights of other OPS community members. By minimizing credible allegations of retaliation and erecting procedural roadblocks to municipal liability, the court sends a dangerous message that school districts may suppress dissent and criticism without robust legal consequence. It's almost as if the court believes that outside observers and other members of the community would not be dissuaded from simply knowing the truth and witnessing the actions taken against Mr. Riddle. This apparent disregard for core First Amendment protections is wholly incompatible with the judiciary's essential role in safeguarding individual rights against government overreach. Taken together, these deficiencies in the district court's analysis reflect a pervasive bias against Mr. Riddle's claims, and abdication of the court's duty to engage. 42. Objectively with the full evidentiary record, and a deeply concerning lack of regard for the constitutional principles at stake in this case. The dismissive tone, selective emphasis on favorable defense evidence, insinuations about improper plaintiff motives, and elevation of procedural technicalities over substantive justice all point to a proceeding that was fundamentally tainted by partiality and insufficient rigor. Accordingly, this court should reverse the decision below and remand for a full and fair adjudication of Mr. Riddle's claims, consistent with the paramount judicial obligations of impartiality, objectivity, and fidelity to the rule of law. Finally, in light of the serious concerns raised about the district court's handling of this case and apparent predisposition against providing Mr. Riddle a fair hearing, appellant respectfully requests that this court exercise its supervisory authority and direct that this matter be reassigned to a new district judge on remand pursuant to 28 U.S.C. Section 2106. When a judge's rulings, remarks, or actions create a reasonable appearance that impartiality may be compromised upon remand, reassignment to preserve the appearance of justice is appropriate. See, e.g., United States v. Martin, 865 F3D 1004, 1013 8th CIR. 2017. Here, the totality of the circumstances, the judge's conclusory rejection of plausible claims, failure to address key evidence, and indicia of a predisposition towards dismissal necessitate reassignment to protect Mr. Riddle's right to be heard by a truly impartial arbiter. Accordingly, if this court reverses the judgment below, appellant respectfully 43. Requests that this matter be remanded to a different district judge to ensure complete fairness and the appearance thereof in all further proceedings. B. The Eighth Circuit's briefing schedule order further demonstrates bias and lack of procedural fairness. The Eighth Circuit's briefing schedule order, which disregarded timely addressing Riddle's properly filed opening brief, is a blatant violation of procedural rules and suggests a lack of respect for pro se litigants. This is a continuation of the pattern of disregard for Riddle's rights. B. The Nebraska Attorney General's office's actions further undermine the integrity of the legal system. A. The sham investigation. The Nebraska Attorney General's office conducted a sham investigation into an open meetings complaint filed not by Riddle or his mother, but by multiple members of the community who bore witness to the actions of Omaha Public Schools Board of Education leadership failing to provide him with due process in notifying him of this investigation or consider his evidence. This suggests a pattern of collusion between government agencies and the entities they are supposed to oversee. The Attorney General's office conducted the investigation without ever notifying 44. Riddle or his mother, the alleged victims. They did not solicit Riddle's testimony or evidence, and they ultimately issued a letter concluding that OPS had not violated the Open Meetings Act. ID. The letter, however, contained false statements about Riddle and his mother, claiming they were the abusers, not the victims, of the alleged Open Meetings Act violations. ID. Riddle was not made aware of this letter until he discovered it by accident in May 2024. ID. The damning silence, OPS's refusal to wield their silver bullet. In the annals of legal strategy, rarely does one encounter a more baffling and potentially damning decision than Omaha Public Schools' inexplicable refusal to utilize the Attorney General's investigation as a defense in their ongoing litigation. This is not merely an oversight, it is a glaring omission that speaks volumes about the integrity, or lack thereof, of the entire process. Consider the sheer magnitude of this decision. OPS, when faced with allegations of misconduct and constitutional violations, chooses to remain silent about an official state investigation that purportedly exonerates them. This is akin to a defendant in a murder trial withholding evidence of their alibi. It defies not just legal logic, but common sense itself. The implications of this silence are staggering and multifaceted. 1. Validity of the investigation. OPS's reluctance to cite the AG's findings raises serious questions about the investigation's legitimacy. If the process was as thorough and impartial as it should have been, why shy away from its conclusions? 45. This suggests a tacit acknowledgement of the investigation's flaws or biases. 2. Conspiracy of silence. The decision not to use this silver bullet points to a possible collusion between OPS and the Attorney General's office. It implies a shared understanding that scrutiny of the investigation would not withstand legal or public scrutiny, revealing a deeper, more systemic issue of governmental overreach and opacity. 3. Consciousness of guilt. In legal parlance, this could be construed as a consciousness of guilt. OPS's silence speaks louder than any defense they could muster, implicitly admitting that they know the investigation's findings are built on a foundation of sand. 4. Erosion of public trust. This calculated omission further erodes public confidence in both OPS and the broader system of checks and balances. It sends a chilling message that even when official channels produce favorable results, those in power will bury them if they fear closer examination. 5. Legal strategy backfire. Ironically, by not using this evidence, OPS has inadvertently strengthened the plaintiff's case. Their silence has transformed what could have been their strongest defense into a glaring weakness, begging for explanation and scrutiny. 6. Indictment of the system. Perhaps most tellingly, this refusal indicts not just OPS, but the entire ecosystem of governmental accountability. It suggests a pervasive culture where even favorable official findings are viewed as liabilities rather than assets, pointing to a fundamental breakdown in the machinery of 46. Justice and oversight. In conclusion, OPS's decision to holster what should have been their most potent weapon is not just a tactical blunder, it is a revelation. It lays bare a system so corroded by self-interest and fear of genuine scrutiny that it would rather face damaging allegations head-on than risk exposing the flawed processes that nominally cleared them. This is not mere incompetence, it is a silent confession of a much deeper, more insidious problem that strikes at the very heart of governmental integrity and public trust. Riddle subsequently contacted the Attorney General's office to express his concerns about the sham investigation and the false statements in the letter. R.Doc. 33-1. The Attorney General's office refused to correct the errors in the letter, refused to provide Riddle with any information about the investigation, and ultimately banned Riddle from the Attorney General's office. ID. The Attorney General's office's actions are a clear violation of the principles of due process and equal protection. Riddle was denied the right to be heard and to have his evidence considered. The office's actions demonstrate a disturbing willingness to protect the interests of the powerful at the expense of the rights of ordinary citizens. B. The Nebraska Attorney General's office's actions demonstrate a pattern of systemic bias. The Nebraska Attorney General's office's actions in this case are not an isolated incident. They are part of a broader pattern of systemic bias and misconduct that 47. Has been documented in numerous other cases involving pro se litigants. In the case of Charter West Bank vs. Riddle, the Nebraska Supreme Court unanimously reversed a lower court ruling in favor of Riddle, finding that the lower court had ignored substantial evidence of bank misconduct. R.Doc. 33-1. This case demonstrates that even when a pro se litigant is ultimately successful, they may still face significant obstacles and unfair treatment in the courts. The Nebraska Attorney General's office's actions in this case are a stark reminder of the serious challenges that pro se litigants face in our legal system. These challenges are exacerbated by the systemic bias that often prevails in favor of institutional defendants and against those who lack legal representation. 7. The broader implications of this case for civil rights and democracy. A. Chilling effect on free speech and public participation. The actions of OPS, the District Court, and the Nebraska Attorney General's Office in this case have profound implications for free speech and democratic participation. By dismissing Riddle's claims and failing to address the serious allegations of retaliation and viewpoint discrimination, the courts have essentially given school districts and other government entities a green light to suppress dissent without consequence. This outcome could have a severe chilling effect on public participation in school. 48. Board meetings and other forums for civic engagement. Citizens may be deterred from speaking out on important issues for fear of facing similar retaliation and then being denied recourse in the courts. This chilling effect strikes at the heart of our democratic system, which relies on robust public debate and citizen oversight of government institutions. B. Erosion of trust in public institutions. The conduct of OPS officials, the District Court, and the Nebraska Attorney General's Office in this case undermines public trust in key democratic institutions. When citizens observe government officials apparently colluding to silence critics and courts seemingly rubber-stamping such behavior, it erodes faith in the fairness and integrity of our system of governance. This erosion of trust can have far-reaching consequences. It may lead to decreased civic participation, increased cynicism about government, and a general weakening of democratic norms and institutions. In an era of rising authoritarianism globally, maintaining public trust in democratic processes and institutions is more critical than ever. C. Unequal access to justice. This case highlights the severe disadvantages faced by pro se litigants in our legal system. Despite presenting substantial evidence and well-pleaded claims, Riddle's case was dismissed without proper consideration. This outcome suggests that 49. Individuals without the resources to hire legal representation may be effectively denied access to justice, even when they have meritorious claims. This inequality in access to justice undermines the fundamental principle of equal protection under the law. It creates a two-tiered system of justice where powerful institutions can violate citizens' rights with impunity, while those same citizens are left without effective recourse. D. Implications for administrative law and government accountability. The Nebraska Attorney General's Office's conduct in this case raises serious questions about the integrity of administrative investigations and the accountability of government agencies. If oversight bodies can conduct sham investigations, ignore evidence, and then refuse to correct false statements, it severely undermines the public's ability to hold government institutions accountable. This case thus has broader implications for administrative law and the balance of power between citizens and government agencies. It suggests a need for stronger safeguards to ensure the integrity of administrative investigations and to protect the rights of individuals who raise complaints against government entities. E. The role of the federal courts in protecting constitutional rights. 50. Finally, this case underscores the critical role that federal courts play in protecting individual constitutional rights. When state institutions fail to safeguard these rights, federal courts are often the last line of defense. The district court's failure to engage meaningfully with Riddle's constitutional claims represents an abdication of this crucial responsibility. If the judiciary again flagrantly disregards the incontrovertible evidence of its own misconduct and that of the Attorney General's office, and indeed the defendant, Omaha Public Schools, as well as the rest of those in Nebraska slated with protecting the constitutional rights of Nebraska citizens, it will forever have surpassed all reasonable bounds. It's as if the entire legal system, in a fit of self-destructive hubris, has not merely gambled away its integrity, but systematically liquidated every asset of public trust. We now bear witness to the spectacle of Lady Justice herself, stripped of her robes and blindfold, standing barefoot before a street hustler's three-card Monte table. With each shuffle and misdirection, she wagers the last vestiges of her authority, seemingly determined to prove a point through her own ruination. This is no mere lapse in judgment, it is a deliberate, almost manic demonstration of how far our venerated institutions will go to assert their imperviousness to accountability, even at the cost of their foundational principles. This court now has the opportunity to reaffirm the importance of federal judicial review in protecting constitutional rights. By reversing the district court's dismissal and allowing Riddle's claims to proceed, this court can send a powerful message. 51. About the judiciary's commitment to upholding the Constitution and ensuring that all citizens have access to justice. 8. Conclusion and prayer for relief. For the foregoing reasons, Appellant Justin Riddle respectfully requests that this court 1. Reverse the district court's dismissal of his claims and remand for further proceedings. 2. Direct that the case be reassigned to a different district judge on remand to ensure fairness and the appearance of impartiality. 3. Provide clear guidance on the proper application of municipal liability standards. Under Section 1983, emphasizing that a single unconstitutional action by a policymaker can be sufficient to establish liability. 4. Reaffirm the importance of protecting First Amendment rights in the context of public school governance and civic participation. 5. Address the systemic issues raised by this case, including the treatment of pro se litigants and the need for robust judicial review of constitutional claims. 6. Consider issuing a broader ruling or statement addressing the importance of maintaining public trust in democratic institutions and processes. 7. Grant any other relief that the court deems just and proper. Appellant further requests that this court take judicial notice of the broader pattern of misconduct by Nebraska state institutions, including the Attorney 52 General's Office, as evidenced by the additional materials and cases cited in this brief. Finally, given the significant constitutional issues at stake and the potential broader implications of this case,